Hello friends, today I am going to dictate advanced legal words outlines. So we ready? One, two, three, start. It is held, it is in his evidence, it is in the evidence of, it is laid down, it is laid down in the side of a decision, it is next contended, it is settled law, it is the case of defendant, it is the case of the prosecution, it is unsafe to convict. It is unsafe to rely. It is unsafe to rely on the evidence of. It was contented. It was held. It is argued. It is argued by the learned counsel for the accused. It is argued by the learned counsel for the accused appellant. It is argued by the learned counsel for the plaintiff. It is argued by the learned counsel for the respondent. It is argued by the learned counsel for the defendant appellant. It is argued by the learned advocate for the accused. It is argued by the learned advocate for the defendant. It is argued by the learned advocate by the plaintiff. It is argued by the learned assistant public prosecutor. It is argued by the learned government pleader. It is argued by the learned public prosecutor. It is contended by the learned advocate for the accused. It is contended by the learned advocate for the defendant. It is contended by the learned advocate for the petitioner. It is contended by the learned advocate for the plaintiff. It is contended by the learned counsel for the accused. It is contended by the learned counsel for the accused appellant. It is contended by the learned counsel for the accused appellant. It is contended by the learned counsel for the defendant. It is contended by the learned counsel for the petitioner. It is contended by the learned counsel for the plaintiff. It is further contended by the learned advocate for the accused. It is further contended by the learned advocate for the plaintiff. It is further contended by the learned counsel for the accused. It is further contended by the learned counsel for the defendant. It is further contended by the learned counsel for the petitioner. It is further contended by the learned counsel for the plaintiff. It is further urged by the learned advocate for the accused. It is further urged by the learned advocate for the defendant. It is further urged by the learned advocate for the petitioner. It is further urged by the learned advocate for the plaintiff. It is further urged by the learned counsel for the accused. It is further urged by the learned counsel for the defendant. It is further urged by the learned counsel for the petitioner. It is further urged by the learned counsel for the respondent. It is next argued by the learned advocate for the accused appellant. It is next argued by the learned advocate for the defendant. It is next argued by the learned advocate for the respondent. It is next argued by the learned counsel for the accused. It is next argued by the learned counsel for the accused appellant. It is next argued by the learned counsel for the defendant. It is next argued by the learned counsel for the plaintiff. It is next contended by the learned advocate for the accused. It is next contended by the learned advocate for the defendant. It is next contended by the learned advocate for the plaintiff. It is next contended by the learned counsel for the accused appellant. It is next contended by the learned counsel for the defendant. It is next contended by the learned counsel for the plaintiff. It is next contended by the learned counsel for the respondent. It is next urged by the learned counsel for the accused. It is next urged by the learned counsel for the defendant. It is next urged by the learned counsel for the plaintiff. It is submitted by the learned advocate for accused. It is submitted by the learned advocate for defendant. It is submitted by the learned advocate for plaintiff. It is submitted by the learned counsel for the accused. It is submitted by the learned counsel for the defendant. It is submitted by the learned counsel for the opponent. It is submitted by the learned counsel for the petitioner. It is submitted by the learned counsel for the plaintiff. It is submitted by the learned assistant public prosecutor. It is submitted by the learned government pleader. It is submitted by the learned public prosecutor. It is the contention of the learned advocate for the accused. It is the contention of the learned advocate for the defendant. It is the contention of the learned advocate for the plaintiff. It is the contention of the learned counsel for the accused appellant. It is the contention of the learned counsel for the petitioner. It is the contention of the learned counsel for the plaintiff. It is the contention of the learned counsel for the respondent. It is urged by the learned advocate for the accused. It is urged by the learned advocate for the defendant. It is urged by the learned advocate for the plaintiff. It is urged by the learned counsel for the accused. It is urged by the learned counsel for the defendant. It is urged by the learned counsel for the petitioner. It is urged by the learned counsel for the plaintiff. It is urged by the learned counsel for the plaintiff. Joint family property, joint Hindu family, joint possession, judge of the High Court, judge of the lower court, judge of the Supreme Court, judgment creditor, judgment debtor, judicial function, judicial magistrate, judicial opinion, judicial officer, judicial probe, judicial process, judicial separation, jurisdiction of the case, juvenile offender, Karnataka government, Karnataka High Court, Karnataka Law General, Karnataka Police Act, Karnataka Rent Control Act, Land Acquisition Officer, Land Mortgage, Land Reforms Act, Law of Crime, Law of Estoppel, Law of Inheritance, Law of General, Law of Limitation, Lawful Possession, Lawyer's Notice, Learned Advocate for the accused argued, Learned Advocate for the complainant, Learned Advocate for the defendant, Learned Advocate for the defendant argued, Learned Advocate for the defendant argued, Learned Advocate for the offender, Learned Advocate for the plaintiff, Learned Advocate for the plaintiff argued, Learned argued for the Learned Advocate for the plaintiff argued, Learned Assistant Public Prosecutor, Learned Counsel for the accused, Learned Counsel for the accused appellant, Learned Counsel for the accused argued, Learned Counsel for the defense, Learned Counsel for the defendant argued, first plaintiff, Learned Counsel for the first respondent, Learned Counsel for the petitioner, Learned Counsel for the plaintiff, Learned Counsel for the plaintiff argued, Learned Counsel for the respondent, learned counsel for the second respondent, learned counsel, learned friend, learned judge, learned judge of law, learned, learned judge of the lower court, learned magistrate, learned munsi, learned munsi magistrate, learned public prosecutor, learned prosecutor argued, leasehold property, least weight of evidence, legal representative, lesser or lazy. Let me discuss in brief. Let me discuss in brief the evidence. Let me discuss the evidence. Let us see. Locus standi, lower court hazard, lurking house trespass, Madras High Court, Madras Law Journal, malicious prosecution, mandatory injunction, mandatory provisions, marked subject to objection, marked subject to proof, material facts of the case, medical certificate, medical college hospital, medical evidence, medical jurisprudence, medical officer, members of an unlawful assembly, memorandum of appeal, memorandum of transferor, memorandum of transferor, mercenary profits, mutes and wounds, minimum wages act, mischief by fire, misconception of fact, misjoinder of charges, misjoinder of parties, misrepresentation of facts, mistake of fact, mitakshara, mitakshara co-personary, mitakshara law, Modi's medical jurisprudence, modus operandi, Mohammedan law, mortgager and mortgage, motor vehicles act, motor vehicles taxation, movable and immovable, movable property, multiple bonds, municipal commissioner, municipal council, mutatis mutandis, my learned predecessor, mutatis mutandis, Mysore General Clauses Act, Mysore High Court, Mysore Law General, Mysore Police Act, negligence of the driver, negotiable instrument, next argued, next contention, next point for our consideration. No evidence is adduced, no evidence is forthcoming, no order as to costs, non adequate lengths, non valuable offense, non valuable warrant, non testament instrument, notice of sale of such assembly, office copy of the letter, office copy of the notice, official assignee, official liquidator, official receiver on consideration of the evidence. on or after, on or before, on the facts and circumstances of the case, on the same day and time, open, close, opposite direction, or in the alternative, orders to be written, partnership deed, Punjab High Court, pari-material, pecuniary interest of government, penalty light, penal provision, pending inquiry, peremptory direction, peremptory orders, permanent injunction, persuasively argued, persuasively submitted, persuasively urged, placing the evidence pros and cons, planned schedule house, planned schedule mentioned, planned schedule properties, planned schedule site, plaintiff petitioner, plausible explanation. Police officer, police station, point for consideration, point for determination, point for determination, postmortem, postmortem certificate, postal acknowledgement, power of attorney, power of attorney holder, prevention of cow slaughter, pre-partition debate, predecessor in little, preliminary degree, preponderance of judicial opinion, preponderance of judicial opinion, Prevention of Corruption Act, previous conviction, principal municip, principles of equitable estoppel, principle of natural justice, principles of res judica, private complaint, probabilities of the case, probate claim, probate court, provision of offenders act, property in question, prosecution has to prove, prosecution cites evidence, provisions of section, public analyzed, public nuisance, punishable under chapter, punishable under section, punishable under such law, punishable with imprisonment, railway property, railway protection force, rashness and negligence, rush and negligent, rush and negligent act, rush and negligent manner, rashly and negligently, ratio dissidentity, registered agreement, registered document, registered letter, registered notice, registered owner, registered relinquished deed, registered sale deed, registered trust deed, registration certificate, read with rule, read with this section, reasonable apprehension, rebuttable evidence, reduced to writing, rigorous imprisonment, relinquishment deed, reorganization of states, reply notice, res integra, res judicata, representation of people's act, restitution of conjugal rights, revision petition, right of appeal, right of claim, right privilege, obligation or liability, rights title of and interest, sealed it, sanitary inspector, Sarkar's Evidence Act, scene of occurrence, scene of offense, schedule, mentioned house, schedule, mentioned property, search warrant, second class magistrate, second defendant, second plaintiff, security for good behavior, security for keeping the peace, security proceedings, self-serving evidence, self-serving statement, sentence to undergo, sentence to undergo, sentence to undergo SI, serious infirmity, serious infirmity in the case of the prosecution, sessions judge, shares and securities, shock and shop and establishment act, short point for consideration, so cause why you should not be, so cause why, simple imprisonment since the time immemorial, signed die, site valuation, solitary evidence, specific performance, specific relief, standing order, State Road Transport Corporation, stated before me, stated in his evidence, statement before the court, statement before the police, stated before the police, statutory provisions, stock in trade, stolen articles, stolen property, strenuously argued, strict proof, subdivisional magistrate, subordinate courts, subordinate judge, substance of the accusation, sum and substance of the accusation, suit for declaration positions, suit for dissolution of, suit for dissolution of marriage, suit for dissolution of the partnership, suit for partition, suit for possession, suit for restitution of conjugal rights, suit house, suit for preemption, suit promissory note, suit schedule house, suit schedule mentioned, suit schedule plot, suit schedule site, suit valuation, suspicious circumstances, suspicious manner, suspended for a period of, take it for granted, taking for granted, taking into account, taking it for granted, taking the entire evidence into consideration. Taluka Magistrate, Telegraphic Wire, Unlawful Possession Act, temporary injunction, testamentary document that you own or about their lordships have held, their lordships have observed, their lordships have stressed, their lordships of the Allahabad High Court, their lordships of the High Court, their lordships of the Karnataka High Court, their lordships of the Kandras High Court, their lordships of the Supreme Court. There is no direct evidence. There is not an lot ideas of evidence on record. There is no evidence forthcoming. There is nothing in the evidence of. There is nothing on record. Valuation of the suit vehemently argued, vehemently contended, vehemently urged, vehemently stressed, vehemently argued by the learned advocate for the accused, vehemently argued by the learned counsel for the petitioner, vehemently argued by the learned counsel for the plaintiff. This is a charge sheet. This is a suit. This suit vehemently argued by the learned counsel for the accused, vehemently argued by the learned counsel for the defendant, vehemently argued by the learned counsel for the plaintiff. Transfer of Properties Act, Treasure Trove Act, vehemently contended by the learned counsel for the accused, vehemently contended by the learned counsel for the defendant, vehemently contended by the learned counsel for the plaintiff. Vendor and vendee, ultimate analysis, ultra wires, undivided Hindu family, universal done, universal legatee, unlawful assembly, unlawful constitution, voluntary statement, voluntarily caused grievous hurt, unlawful position association, unnatural death, unnatural offense, unrebuttable evidence, unregistered document. We can infer, weigh the evidence cautiously, weight of evidence, weights and measure, well established principle, validity, contraction of execution, valuable security, well established principle of law, well laid down, when such being the case, when such is the case, which is laid down within the cognizance, bond certificate, writ of certiorari, writ of habeas corpus, writ of mandamus, writ petition, written statement, wrongful confinement, wrongful gain, wrongful gains, wrongful loss, appendix to the family of the plaintiff, appendix to the family of the plaintiff, code of criminal procedure, execution of warrant. He has stated in his evidence. He has further stated in his evidence. High Court of Judicature at Bombay. Honorable Court may be pleased to call for. Honorable Court may be pleased to call to degree the suit. Honorable Court may be pleased to direct. Honorable Court may be pleased to dismiss. Honorable Court may be pleased to order in furtherance of the common object. Code of Civil Procedure, counterfeit, government stamp, damages for malicious prosecution. It is argued by the learned advocate appearing for the accused. It is argued by the learned advocate appearing for the petitioner. It is argued by the learned advocate appearing for the respondent. Declare the suit schedule mentioned property. Destroy, damage, or defile. It is argued by the learned counsel appearing for the defendant. It is argued by the learned counsel for the differing for the plaintiff. Discriminatory, division bench of the High Court, division bench of the Karnataka High Court, division bench of the Supreme Court, Chief Judicial Magistrate, Food Adulteration Act, executive orders, It is further contention of the learned advocate for the accused. It is further contention of the learned advocate for the defendant. It is further contention of the learned advocate for the accused. It is further urged by the learned counsel appearing for the accused. It is further urged by the learned counsel appearing for the petitioner. It is urged by the learned advocate appearing for the petitioner. It is urged by the learned advocate appearing for the plaintiff. It is stated in his evidence. It is stated in the evidence of PW. It is the next contention of the learned counsel for the accused. It is the next contention of the learned counsel for the defendant. It is the next contention of the learned advocate for the accused. It is the next contention of the learned advocate for the defendant. Judicial magistrate first class. Judicial magistrate second class. Jurisdiction of this court. Justice of peace. Learned advocate appearing for the accused. Learned advocate appearing for the defendant. Learned advocate appearing for the plaintiff. Malicious security proceeding. Mischief by killing. Mitakshara co-personally estate. Mitakshara co-personary property. Mitakshara family. Mitakshara school. Objection overruled. Objection sustained. Partition and separate position. Points for consideration. Prayed for an adjournment. Prayed to condone the delay. Prayed to degrade the suit. Prayed to dismiss the application. Prayed for dismissal of the suit. Prayed for dismissal of the suit. Prayed to reject the application. Preliminary issue. Small cause court. Went on arguing. Went on arguing. Went on to contend. Went on contending. Absolute owner of the plaintiff scheduled property. Absolute owner of the property. Absolute owner of the suit house. Absolute owner of the suit schedule house. Acquitted of the offence with which they are charged. Acquittance of the offences with which they are charged. Adjudicated insolvent. Advance on behalf of the accused appellant. Advanced on behalf of the plaintiff. Advance on behalf of the defendant. Advance by the learned advocate for the accused appellant. Advance by the learned advocate for the plaintiff. Advance by the learned counsel for the accused appellant. Annulment of the marriage argued before me by the learned advocate for the plaintiff. Learned advocate for the plaintiff. Argued by the learned counsel for the plaintiff. Argued on behalf of the accused. Argued on behalf of the complainant. Argued on behalf of the defendant. Argued on behalf of the plaintiff. Categorically stated in his evidence. Contention advance on behalf of the plaintiff. Contention advance on behalf of the plaintiff. Contention advance on behalf of the respondent. Convicted and sentenced. Convict and sentence the accused. Conviction and sentence. Conviction and sentence passed by the learned judge. Conviction and sentence passed by the learned magistrate. Declaration and injunction. Decree or order of the civil court. Exchange of words. Failed to bring home the guilt of the accused. For the same of arguments. In the public interest. In the case of the complainant. It is the case of the plaintiff. I am of the firm opinion. In possession and enjoyment of the properties. Interest testimony of PW. It is contended by the learned counsel for the first defendant. It is contended by the learned counsel for the plaintiff. It is contended by the learned counsel for the second plaintiff. On the date of incident, on the date of occurrence, on the date of offense, orders to be destroyed, order to be returned, possession and enjoyment of the land, possession enjoyment of the land, possession enjoyment of the settled mentioned property, possession and enjoyment of the suit settled house, public service commission, quasi judicial proceedings, sentence to suffer RI, sentence to suffer SI, specific relief, specific time to limitation, state public service commission. Taking all these facts into consideration, there is good force in this contention. There is good force in this contention. Urged on behalf of the accused appellant, urged on behalf of the defendant, may have mentally argued before me, with which he is charged. Amicus curiae caused disturbance to the public peace, claim for alimony, claim for compensation, commission warrant, cooperative movement, doctrine of stare diseases, Hindu law of inheritance, Hindu Women Rights to Property Act, housebreaking by night, husband and wife. I move the firm view in order to bring home the guilt of the accused, insult, annoy, or intimidate, insult, intimidate, or annoy, intimidate, annoy, or insult, intimidate, insult, or annoy. It is well established law. It should go to so. May I take the opportunity? Misjoinder of cause of action, order of inheritance, predecessor in interest, prevention of adulteration act, private defense, proximate result, speaking order, special magistrate, states reorganization act, strictly scrutinized, subject to objection, suo motu, tenants in common. There is good force in this allegation. This would go to so. This would go to so.